Esteems and gentlemen, in the last class, I was telling you the various factors you have got to take into account while studying about discharge of contract. A contract may be discharged by performance. Contract may be discharged by mutual consent. It may be novation, a remission, a rescission, tender, merger, assignment, alteration, and so on and so forth. And the contract may also be discharged by impossibility, by operation of law, by breach. In this connection, you will remember that I told you performance is the best way of discharge of contract. Then I told you what are the factors you have got to study under the subheading performance. When is performance due? First aspect. In that connection, we spoke about conditional contract and absolute contract. Conditional contract are of two types. Condition being imposed on account of human interference and contingent due to events which are considered to be uncertain, which is known as contingent contract. Then we spoke about the order of performance. Under that, mutually independent, mutually dependent, and mutually concurrent. Section 51, Section 54, and Section 52. These are the sections we have dealt with. And then mode of performance, how to perform, where exactly it has to be performed, when it should be performed. And then in this connection, we also told you about the aspects of synchronization of supply of material and manufacturing program, which is an important topic under material management. We spoke about section 48, 49, so on and so forth. Then today we are going to deal who is entitled to enforce performance. Yesterday I told you who is to perform, where personal skill and labor is involved. Only the person whom you specify to perform the obligations, he alone should perform. The promisor alone should perform. The promisee can insist that promisor should perform. And where personal labor and skill are not involved, personal labor skill are not involved, any person can actually execute the obligations under the contract. Now today we are going to speak about the important topic, who is entitled to enforce performance. Who is to perform? That we have already seen. Who is entitled to enforce performance? In this connection, I would like to clarify the fundamental principle you have got to understand. Please understand the fundamental principle, rudimentary aspect. Number one, under Indian law, any liability is considered to be joint and several. You must understand that under Indian law, any liability is considered to be joint and several. Even though it might have been mentioned as joint liability, even then any joint liability is construed and understood as joint and several. So far as England is concerned, the English law is concerned, there they make a distinction between joint liability and joint and several liability. Now, so far as Indian law is concerned, you have got section 40, 41, 42, 43, 44. These are the important sections which speak about joint and several liability. Now let us understand first the difference between the English law, which distinguishes between joint liability and joint and several liability. Now what is meant by joint liability? Take for example, here you see X, a creditor, he actually gives loan to A, B and C. These are the people who are getting loan. You can understand it. X creditor advances loan of rupees 1000 each to A, B and C and takes a joint promissory note from all the three of them. A gives 1000 rupees to A, B and C and takes a joint promissory note from all the three of them. Now, under the English law, when it is mentioned as joint liability, what will happen? Supposing A dies, what will happen? B and C alone will be liable to repay the 3000 rupees which they have got by way of loan. Each of them got 1000 rupees as loan. Supposing the loan that has been borrowed by A, it could not be repaid because A has expired. Who has got to bear that liability? Not A's legal representatives. B and C alone will be liable. The liability devolves by survivorship. Please understand it very clearly. So far as joint liability is concerned, the liability of A has to be shared. The liability of A has to be shared by B and C. Supposing B also dies, C alone will be liable to pay the 3000 rupees alone. Supposing C dies, the legal representatives of C will become liable to repay the loan. So, in the case of English law, when you mention it as joint liability, the liability devolves by survivorship. But so far as English law is concerned, when it mentions the liability as joint and several liability, in that particular instance, when A has borrowed 1000 rupees, B has borrowed 1000 rupees, C has borrowed 1000 rupees. Supposing A has chosen not to actually collect the money from A, but he wants to collect the money from B and C, then what will happen under English law? Then he cannot realize the money at all. He cannot realize the money from A because he has relinquished his right against A. So he can actually collect money only from B and C, namely 1000 rupees each will pay. So he can only realize 2000 rupees. So far as 1000 rupees is concerned, he is deemed to have relinquished his right. In the case of joint and several liability, where he has relinquished his right. But so far as joint liability, under joint liability, if A relinquishes, it is not under joint and several liability. Please understand. I am sorry I have not told you properly. In the case of joint liability, when A, B and C have borrowed rupees 1000 each, supposing A relinquishes his right against, the creditor, namely X only has advanced money to all the three of them, each 1000 rupees. Supposing X has relinquished his right against A, he cannot realize the money at all. He is deemed to have relinquished his right against A. He can collect only from B and C 1000 rupees each. That means he can collect only 2000 rupees. That is in the case of joint liability. In the case of joint and several liability, under English law, it actually devolves by separate liability. That is, supposing A dies, the legal representative of A along with B and C will become liable. In the case of joint and several liability. Supposing A dies and B also dies, then what will happen? The legal representative of A along with the legal representative of B with C will be liable. Supposing all the three of them, they die, A, B, C, all the legal representatives of A, B and C, they alone will become liable to repay the loan. So this is what is known as joint and several liability. So far as India is concerned, any liability, whether you call it as joint liability or joint and several liability, every liability will be considered and construed only as joint and several liability. That means what will happen if X wants to file a suit against A, B and C, supposing A dies, he has to collect the money from the legal representatives of A along with B and C. Supposing B also dies, the legal representative of A along with legal representative of B with C will be liable. If all the three of them they die, what will happen? The legal representatives of A along with legal representative of B along with legal representatives of C will become liable to repay the loan. That is what you should understand. Now, that is what is known as the promisors who are liable. So, what you should understand is, under English law, they make a distinction between joint liability and joint and several liability. In the case of joint liability, the liability devolves by survivorship. In the case of joint and several liability, the legal representatives of the deceased members are also liable along with the surviving promisors. Now you should understand that in case the promisees are considered to be a joint promisee, what will happen? Supposing A and B are the creditors, they have advanced loan to C. Please understand it clearly. A and B are the creditors. They have advanced loan to C. Supposing A alone wants to file a suit, is it possible? No. A cannot actually file a suit because the suit will become bad on account of non-joinder. Non-joinder means an essential party to the litigation who has not been impleaded or included as a party. So the suit will become bad on account of non-joinder. The parties who have got to be impleaded and included, when they are not included, the suit will not be taken up for litigation. Supposing A and B alone, they have got a right. Instead of A filing a suit, he actually files a suit along with A and B, and C and D also is included in filing a suit against C. See, C is the debtor. A and B are the creditors. Now what happens? A and B along with D, who is not at all a party to the litigation, they file a suit. In fact, C has not executed a promissory note in favor of A, B and D. He has executed a promissory note only in favor of A and B. But they have also impleaded or included D. Now the suit is bad for misjoinder. Misjoinder means a person who has not to be included. So a suit becomes bad on account of non-joinder by not including a party who is a necessary party to the litigation, and by adding a party who is not at all to be included, a party who has nothing to do with the litigation. Supposing that is the suit becomes bad on account of misjoinder. So these are the differences which you should find. Now the essential feature so far as Indian Contract Act is concerned. Now so far as joint and several liability is concerned. Now what will happen? Supposing A and B actually they have borrowed money from X, 1,000 rupees each. They have executed a joint promissory note. Now what happens? Supposing A actually owes rupees 2,000. They have, all of them have executed. We have borrowed a sum of 2,000 rupees and they have signed jointly. Each one of them would have taken in between themselves, they would have taken 1,000 rupees each. But so far as the amount is concerned, it is a consolidated amount that has been stated on the promissory note, and they have borrowed and they have signed together. Now what happened? Now so far as when liability accrues, now the creditor X can file a suit against A alone and recover the entire amount of 2,000 rupees which they have jointly borrowed. Now what will happen to B, sir? D has collected the entire money from A. What will happen to the amount that is due and payable by B? B has got to contribute to A in respect of his portion of money which he actually owes to X, the creditor. So A has paid 2,000 rupees, out of which both of them got 1,000 rupees each, in which case, in as much as A has paid the entire 2,000 rupees to the creditor X, now what will happen? The A will step into the shoes of the creditor and collect that part of the money which he has paid on behalf of B. This is what is known as subrogation. The creditor who has paid the money on behalf of the other he will step into the shoes of the person to whom the money has been made, and he will collect the money from the person on whose behalf he has remitted the money. This is what is known as subrogation. If there are more people, it will, first of all, there is a subrogation, and then all of them have got to contribute. Contribution, subrogation and contribution. They have got to contribute in respect to the portion they have borrowed by way of loan. So, this you have got to understand. So far as Indian law is concerned, you find under section 42 and the relevant sections therein that any promisor who has paid on account of the co-joint promisor can step into the shoes of the promisee and collect the money due and payable by the co-joint promisors to the promisee. They have got to pay to the promisor who has paid on behalf of them by invoking the doctrine of subrogation, and proportionately they have got to contribute, which means contribution must also be studied there. So, these are the aspects which says about the person who is entitled to enforce the contract. Who is the person who is entitled to enforce the contract? So far as performance is concerned, if you study this much, that is more than enough. So, what are the things which you have studied under performance? When is performance due? The order of performance, the mode of performance, who has got to perform the contract, where personal labor and skill is required, only the promisor should perform the contract. Robson and Sharp versus Drummond, we have seen that case. And then lastly, who is entitled to enforce the obligations under the contract? There we have said about joint liability and joint and several liability. This much we have got to study with regard to performance. Then, what is the second way by means of which a contract is discharged? A contract is discharged by novation, section 62, by novation. That is by mutual consent. And by mutual consent, contract may be discharged. Under what ways? By novation. Second, by remission, by rescission, then by assignment, by material alteration, by merger. So these are all the various ways under which by mutual consent a contract may be discharged. Novation means what? New contract. An old contract is replaced by new contract. A new contract is substituted for old contract. Now let us take a simple example. A has advanced money to B. B owes money to A because A is the creditor, B is the debtor. Now already C has also borrowed from B. A has actually advanced money to B. B is a debtor to A, and C has borrowed money from B, and C is a debtor to B. The exact money also is the specific money, that is a specified amount. A has actually advanced 1,000 rupees. Take for example 1,000 rupees he has advanced to B. So B owes A 1,000 rupees, and C has borrowed 1,000 rupees from B. Now C owes 1,000 rupees to B. Now in this case what will happen? Instead of B repaying the money to A, he can direct C to pay money to A, and A also must accept it. When once A accepts to receive the money that is due and payable by B to be paid by C, this contract is known as new contract or novation. Novation. In this connection, since you are a student of company law, it is better to know about the leading case. That is a case, Podar, Sholapur Spinning and Weaving Mills. Podar Ramachandra versus Sholapur Spinning and Weaving Mills. Say Podar Ramkumar versus Sholapur Spinning and Weaving Mills. Ramkumar Podar. That is a leading case. In this case, the promoters of a company entered into contract with third parties for the purpose of obtaining materials for the company they intended to incorporate. They wanted to start a company on raw materials. So these promoters, on behalf of the company which is going to come into existence later, they entered into contracts with third parties who are dealers. They obtain materials for the company which they thought of incorporating. Now what happens? In this case, the materials were advanced by the suppliers to the promoters, and these promoters actually made use of it for the company. Then when once the money has become due and payable, these third parties who have supplied the materials, instead of filing a suit, they filed a suit against the company. The company has been sued by the suppliers of these materials. Then the question came up for consideration whether the promoters are agents of the company. Promoters, they have actually entered into a contract for taking delivery of the materials before the company has become incorporated. Before the company could incorporate itself, before the company can come into existence, these people have actually entered into transaction with the suppliers of materials for obtaining supply of materials. Now the company has not come into existence. Now can you call these promoters as agent? How can these promoters act as an agent for a non-existing principle? There is a famous case, ratification must be Kellner versus Baxter. That is a leading case. But however here, Ramkumar Podar versus Sholapur Spinning and Weaving Mills, that is a very nice case for narrating novation. That is, novation is a new contract. For the purpose of narrating the example, novation, this is the best case. That is where these promoters actually borrowed the materials on credit for the incorporation of the company. Then later on, company came into existence, and when a suit was filed by the suppliers of these materials, the court said you cannot actually file a suit because the promoters are not considered to be the agent of the company, because the company cannot be considered as a principal because the company itself has not come into existence. So inasmuch as the principle has not come into existence, how can you say that promoters have acted as an agent for non-existing principle? And ratification also is not possible. So what they have got to do, solve the problem, these promoters have got to enter into fresh contract with the suppliers of those materials to the company to be incorporated under de novo, a fresh contract. Whereas Mr. So-and-so have acted as promoters of such and such company, now that the company has become incorporated, they are entering into a contract with this. By this contract, they are entering into an agreement to repay whatever money that is due and payable borrowed by the people, these people, namely 1 and 2 and 3 as promoters of this company. So we hereby undertake to repay the entire loan that has been borrowed by our promoters by this deed of agreement. So when they actually enter into a fresh contract, that is what is known as novation. So a contract may be discharged by novation based on mutual consent. A contract may also be discharged by assignment. Assignment means what? Assignment can be pertaining to liability and pertaining to benefit. Supposing it pertains to liability. Liability always arises with regard to fulfillment of obligation by the promisor. Promisor can only assign liability. Promisee can assign benefit because he is on the receiving side. Who? Promisee. So when the promisor wants to assign his right where personal skill and personal service is not involved, he can definitely assign his obligation to somebody else to perform on his behalf the obligation or service which he has got to render in favor of the promisee. Supposing A has entered into a contract with B for supply of 10 bags of paddy. Now B, before December, you must understand time also. So before December, the contract is that B should supply 10 bags of paddy to A before the end of December. Now B wants to assign this in as much as he is not having sufficient stock in his godown. Now B assigns his obligation to C to perform the contract, to perform the obligation service which he has undertaken to do for this person. So here B, instead of B performing the service, he can ask C to supply 10 bags of paddy to A. B has promised to supply 10 bags of paddy to A. B is not in a position to supply these bags. He is now directing C to supply these 10 bags of paddy, and A also agrees because the same quality, same quantity, and he is also a rice merchant, and when A accepts it, this is what is known as novation. This is novation. Then there is another aspect also. When totally terms and agreements are changed, instead of receiving 12% as commission, a commission agent who is for supplying all these things, he is going to receive some commission. He is changing this commission as 15% instead of 12%. Well, this is also a case of novation. When the terms and conditions of the contract are completely changed by alteration, by mutual consent, this is also a principle of novation. Now, garnishee proceedings under Order 21, Rule 40 of the Civil Procedure Code. Who is a garnishee? A garnishee is debtor's debtor. Sir, I don't understand debtor. Supposing an employee of a company as a worker, he has borrowed money from the money lender. Now, who has got to repay the money? The employee of the company has got to repay the money which he has borrowed from the money lender. Now, the worker is not able to pay, he doesn't have money. Bonus is declared for Deepavali. Now, what will happen? The money that is due and payable to the worker, the company owes the money to the worker because the company has got to pay bonus to the worker. Who is the worker? He is a debtor. Who is a debtor's debtor? Company is debtor's debtor. Debtor is the money lender is the creditor. The worker in the company is a debtor. Company is a debtor to debtor. So here a judgment debtor's debtor has got to pay the money to the creditor. He can actually obtain a petition from the court and direct the debtor's debtor, namely the company which owes money to the debtor, namely the worker or employee, to pay the money on behalf of the worker to the creditor. This is what is known as garnishee proceedings. Who is a garnishee? Judgment debtor's debtor. So this is also a case of novation.